Bail is a promise to attend court. It means that you're released from custody until your court date. It may be unconditional or have conditions attached to it. A new Bail Act came into force on 20th of May 2014. The old Bail Act, the Bail Act 1978, required consideration of various presumptions, that is, presumptions in favour of bail or presumptions against bail or neutral presumptions. It was complex, confusing and created a number of unfair outcomes. The new Bail Act has done away with these presumptions and it's based on a risk management approach to the determination of bail. Now, the person deciding bail or the bail authority is required to consider whether the applicant, you, poses an unacceptable risk to the community. The bail authority can be a police officer, an authorised justice or a court. And a bail application is now called a release application. When deciding whether to grant bail, the bail authority must decide whether you are an unacceptable risk. Section 17 of the Act says that you are an unacceptable risk if, once released from custody, there is an unacceptable risk that you will fail to appear in court when required, or commit a serious offence, or endanger the safety of victims, individuals or the community, or interfere with witnesses or evidence. Section 12 lists the factors that are to be considered when determining whether you are an unacceptable risk, and they are 1. Your background, including your criminal history, personal circumstances and your community ties, for example, your family situation, whether you have to care for children, how many people you know in Australia, how long you've been here and so on. 2. The nature and seriousness of the offence that you have been charged with. 3. The strength of the prosecution case. 4. Whether you have a history of violence. 5. Whether you have previously committed a serious offence while on bail. 6. Whether you have previously breached bail acknowledgements, bail conditions, apprehended violence orders, parole orders or good behaviour bonds. 7. How long you are likely to spend in custody if bail is refused. 8. The likelihood of a custodial, that is a prison sentence, being imposed if you are found guilty of the offence. 9. If you have been found guilty of the offence and if you have lodged an appeal against the conviction or sentence that was imposed, and whether, if you have, the appeal is likely to be successful. 10. Whether you have any special vulnerabilities, for example, if you are a young person, an Aboriginal or a Torres Strait Islander, or if you have a cognitive or mental impairment. 11. Whether you have a need to be free to prepare for your appearance in court or to obtain legal advice. And 12. Whether you need to be free for some other lawful reason. If you are found not to be an unacceptable risk, then you are to be released without bail conditions. If you are an unacceptable risk, the next question is, can the risk be mitigated, that is overcome, by bail conditions? If the answer to that is no, then bail is to be refused. If the answer is yes, then bail is to be granted with conditions that mitigate, that is, meet the risk. The conditions cannot be more onerous than what is necessary to prevent the risk. Examples of conditions that may be imposed upon bail are that you reside at a particular address, that you or an acceptable person, known as a surety, deposit and agree to forfeit a specific amount of money, known as a security, if you do not appear in court. Enforcement conditions, for example, to report to police on a regular basis, to undergo regular drug and or alcohol testing, or to comply with other police directions. That you do or refrain from doing something, e.g. do not enter a certain area or a certain suburb, or that you do not associate with particular persons. That you surrender your passport and or not go within a certain distance of international points of departure.